The attorney-client privilege protects communications shared in confidence between a client and attorney about the client's legal matters. But what if a third person is present? The answer to that question depends on the third person's role, as explained in United States v. Evans. Chicago police officer and civil attorney John Holden was close friends with Chicago alderman Jesse Evans. When news broke that Evans was under federal investigation for corruption, Holden arranged for Evans to meet with criminal defense attorney James Koch to discuss the matter and Koch's possible representation of Evans. Holden attended the meeting, too. Sometime later, the United States indicted Evans for racketeering, tax fraud, and obstruction. The prosecution filed a pretrial motion to introduce Koch's testimony about the communications that occurred at the meeting. Evans argued that the attorney-client privilege protected the communications from disclosure. The prosecution argued that Holden's presence destroyed the privilege. At the evidentiary hearing, Koch claimed that when the meeting began, Holden said he was there as Evans's friend and couldn't represent him because Holden's police officer position created a conflict of interest. Koch then informed Evans that their conversation might not be privileged if Holden stayed because he was there as a friend. Evans said he understood and insisted that Holden remain anyway. Holden contradicted Koch's version of events. He claimed that Koch didn't inform Evans about the privilege, and he denied ever saying that he wasn't representing Evans or was there as a friend. He also claimed that he attended the meeting as Evans's attorney to advise him about whether he should retain Koch. The district court found Koch more credible than Holden and held that the communications weren't privileged because Holden was there as a friend. Accordingly, the district court granted the prosecution's motion to introduce the communications. Evans appealed to the Seventh Circuit.